Good morning, everyone, and welcome back to Session 2, Day 5 of the Negotiated Rulemaking of Affordability in Student Loans. I am Cindy Jeffries. I will be your facilitator this morning. And to kick things off, we're going to do our roll call of attendees for this morning. So first, I will call the constituency, and then the primary, and then the alternate's name. So for the Department of Education, Federal Negotiator, Jennifer Hung.
Good morning. Happy Friday, everyone.
Good morning, Jennifer. From Office of Attorney General, we have Brian Siegel this morning assisting Jennifer.
Good morning.
Good morning. Accrediting agencies, Heather Perfetti.
Good morning, everyone.
And her alternate, Michael McConis. It's our understanding he's not able to join us. Dependent students, Dixie Samaniego.
Good morning, everyone. Happy Friday.
Good morning, Dixie. Greg Norwood. Doesn't appear as though Greg is with us right now.
Oh, good morning.
Yes, he was just muted.
Good morning from the beautiful city of Houston, Texas.
Good morning, Greg. Federal Family Education Loan Lenders and or Guarantee Agencies, Jay O'Connell.
Morning from Frosty, Vermont.
Good morning. And Will Schaffner.
Good morning. I'm on the road for a little bit today, but I am with you. Hi, everyone.
Okay. Perfect. Thank you. Financial aid administrators at post-secondary institutions, Daniel Barkowitz.
Hello, everyone, from a still beautiful but yet very wet Orlando, Florida today. So welcome, everyone. Happy Friday.
It is very wet down here today, Daniel. You are correct. Alyssa Dobson.
Hi, good morning.
Good morning. Four-year public institutions, Marjorie Doreen Williams.
Good morning, everyone. Dr. Doreen Williams here.
Good morning. Rachel Feldman.
Good morning. Happy Friday, everyone.
Good morning. Independent students, Michaela Martin.
Good morning.
Good morning, Michaela. Stanley Andrees.
Good morning, everyone. Happy Friday.
Hi, Stanley. Individuals with disabilities or groups representing them, Bethany Lilly.
Good morning, everybody.
Good morning, John Whitelaw.
Morning from the proud first state of Delaware.
Good morning, John. Legal assistance organizations that represent students and or borrowers, Persis U.
Good morning from chilly Boston, but I think we're still warmer than Vermont.
I would take you up on that one, Persis. Joshua Robinger.
Good morning, everyone.
Good morning. Minority Serving Institutions, Noelia Gonzalez.
Good morning.
Good morning. Private Nonprofit Institutions, Misty Sobanich.
Good morning from sunny Arizona. Happy Friday, everyone.
Good morning, Misty. And Dr. Terrence McTeer.
Good morning, everyone.
Good morning. Proprietary Institutions, Jessica Berry.
Good morning, everyone.
Hi, Jessica. And Carol Colvin.
Good morning.
Good morning. State Attorneys General, Joseph Sanders.
Good morning from Chicago, everyone.
Hi, Joe. Eric Appar.
Good morning, everyone.
Hi, Eric. State Higher Education Executive Officers, State Authorizing Agencies, and or State Regulators, David Tanberg.
Good morning.
Hi, David. Suzanne Martindale.
Hi, good morning.
Good morning. Student loan borrowers, Jerry O'Brien Lucy.
Hello from the lovely Albany, New York at 36 degrees this morning.
Yikes. Welcome, Jerry. Jennifer Cardenas.
Cardenas, yes. Buenos días. Good morning, everyone.
Good morning. Two-year public institutions, Robert Ayala.
Good morning, ladies and gentlemen.
Hi, Bobby. Christina Tangalakis.
Morning from Los Angeles. I have no right to complain about the weather from here.
Good morning, Christina. U.S. military service members, veterans, or groups representing them, Justin Hochschild.
Good morning.
Good morning, Emily DeVito.
Good morning.
Good morning. Then we have our two esteemed advisors, Raj Darolia on economic or higher education data.
Hello from Lexington, Kentucky, 38 degrees here.
Good morning, Raj. And Heather Jarvis, qualifying employers on the topic of public service loan forgiveness.
Good morning from Wilmington, North Carolina at 44 degrees.
Good morning. Did I miss anyone this morning? Okay, perfect. So with that, I think we'll jump right into our agenda today and pick up where we left off yesterday on the income-driven repayment issue paper. And I believe, Jennifer, you were going through A through D to type. I see Heather has her hand up.
Thank you, Cindy. I just wanted to ask a couple of questions of the department so that I could be more expeditious in providing regulatory text between sessions. Two specific questions. First, whether Ed has evaluated establishing a both and approach to qualifying public service, such as working for a qualifying public service employer, as we currently have, and adding a well-defined limited number of qualifying public service jobs. So my first question is whether Ed has evaluated the idea of establishing a both and approach. If I can receive an answer to that at some point before the next session, I'll be able to better compile materials in an expeditious manner and get them to Ed very quickly. And the second question I have is whether the department has evaluated including full-time public service employment in specifically defined and limited for-profit settings. So the question being whether Ed has considered including some for-profit employment as qualifying. And those are my two questions.
Okay. Got that, Jennifer?
Yes, thank you, Heather.
Okay.
You know, we talked a lot about this. We talked about this even in crafting the proposal. I alluded to the original rulemaking that we did in 2009. We've stewed on it. We've put a lot of thought into this whole concept of just starting with the employer. And so we have not found a way to operationalize that by job description or by type of employment. So we are staying with this concept. So if we could keep our discussions regarding, you know, first accessing the program through employer, tiered concept. So if we can, first entities, we are still taking that into consideration, but again, our challenge with that piece is knowing where to draw the lines, and we haven't found, and nor did our discussion yield a clean way to do that. So we're open to ideas. We realize we are going into the third session. So to your first point, we are staying with eligibility by the employer. And to your second point, we haven't closed the door, but we just, at this point in time, we don't have any good answers for that piece. And it's very slippery as we conceive of it right now.
Thank you, Jennifer. Daniel and Dixie, Let me just make one point of clarification. There may be some confusion on the introduction of Mr. Brian Siegel. He is from the Office of General Counsel and is here to assist. Daniel?
Thank you. Jennifer, can I ask, is the concern one of compensation or is the concern one of role? Because I think either concern, and I'm speaking specifically about someone working in the private sector, either concern has a solution, or maybe it's a combination of both. I'm just trying to get a better sense of the department's concern.
Well, I think it's twofold. I mean, it's qualifying employees by the type of work that it is public service, but it's also the real challenge of finding a way to operationalize that. And so, and to either ensure that we capture those individuals that are performing a public service. I think that's a priority. You know, it's just, are they performing a public service? So, and there's a way that we've been able to operationalize that at an employee level. It's just not feasible for our for the department to be looking through individual job descriptions, or it's just, so then if we start drawing lines about types of jobs, that can be very slippery as well in terms of inadvertently including individuals that aren't performing a public service, for example.
So my alternate has mentioned,
or inadvertently excluding those that are. Sorry, go ahead.
Oh, no problem. So my alternate has mentioned several times SOC codes as a way to get to that as a practical method. And I understand the concern. But I know my alternates mentioned it a few times, and actually SOC codes are a federal designation for occupations, and we've used them in the past in other ways with federal student aid. So again, I would highly encourage us, and maybe I can ask Heather if that's something that she'd be willing to look at, is SOC codes as a way to get to your concern or the department's concern.
So we have used that. I know that was raised, and we've there's still some. It doesn't fill in all the gaps for us going by SIP codes.
Okay, thank you, Dixie.
I think Heather might have something to say. The PSLF advisor. I'm not sure if it's on that. Some of the stuff that I'm talking about is not on PSLF, so if Heather wants to jump in right now before I ask my questions.
Okay, thank you, Dixie. Heather?
Thank you, and I don't want to take time away from the conversation about income-driven repayment. I fully recognize that is absolutely vital that we get to immediately. But in response to Daniel and Jennifer, I do have some very clear ideas and would be happy to continue to work with this committee and representatives of the department to hash that out. I want to acknowledge what Jennifer has said, that I agree completely that we must have the system that the department has put in place of qualifying the overwhelming majority of borrowers for public service loan forgiveness based on their employment with government or 501c3 nonprofit organizations. That is necessary to administer the program in a way that is possible. But it is also possible to have a very narrow and specifically defined additional category that borrowers can apply for consideration and meet the requirements of the department. So it would not be administratively burdensome. I have some suggestions that would make it, in fact, I think much less difficult to administer than the current system. Because what the department presently has to do is look at organizations and bend over backwards to try to determine which organizations are providing public services that are not C3s or governments. And the reality is that virtually all public service workers and public service work is done in government and 501c3 nonprofit organizations. The difficult question is what other public service is happening outside those contexts. And the department presently has to try to look at nonprofit organizations and figure out how much public service they do, or whether they get any public funding, or what their primary function is. And that is very difficult and has resulted in litigation and issues for the department administration. It would be much easier to continue the current system and say we're qualifying everybody who works for the government and everybody who works for a C3 based on their organization of employment. And that process is in place. Then you don't want to miss other people, and you don't want to include folks you shouldn't include. So then you look to your definitions that the department has offered, and potentially additional ones from SOC codes. And I have very clear ideas about how that can work in the current regulatory structure, statutorily approved. The department does not have to only qualify people based on employment in a specific type of organization. They could continue to do that and add a little other something. And I have very specific ideas. Happy to go back and forth on that. But I don't want to spend a whole lot of time and write a lot of things if the department has completely rejected the notion of ever allowing someone to qualify who does not work for an organization that the department has already approved through a process that is difficult. So I'd love to provide some additional text to the department, and I can do that very quickly next week, but I don't want to spend a lot of time doing it if you're not going to consider it.
Thank you, Heather.
Yeah, we'd be happy to take that, Heather. Again, given our very real reservations, but that being said, that was how we broached this discussion for session 2, but we didn't, I don't know about you all, but we left that discussion feeling, that we had more questions rather than answers. So we did we proposed new definitions. We solicited other definitions. If you had more that you could offer us, Heather, we certainly will take a look. But I just want to emphasize what we're trying to balance here in terms of having some rails around the program. Also, I realized Daniel and I were saying SOC codes, and we wouldn't be able to rely exclusively on SOC codes. Alyssa, I know you've broached that several times. We have used that, in the past to kind of as a guide when we receive certain applications, but there are some gaps with SOC codes, so we wouldn't be able to rely exclusively on them.
Thank you, Jennifer. Dixie.
I have a couple questions, and I'll ask them one by one so that Jennifer is able to give an answer to each and every single one of them before we move on to today's topic. So basically, some of these questions are in preparation for next week's Prison Education Subcommittee and ensuring that the department is prepared for that. And so I have a question about whether or not materials will be distributed to the subcommittee folks before the actual start of the week, so that they actually have a time to come, or they have the time to come prepared, or if there's like a timeline when the Department of Education is going to release those materials for the subcommittee.
So you're asking, Dixie, specifically about materials for the subcommittee, not for
that
the
will be distributed for the Prison Education Subcommittee. Yeah, I'm not asking for them myself, but rather, is the department going to get them out before the actual start of the week for them?
Yes, and I see my colleague on the line here, so I'm gonna let
I was gonna ask if it might be a better question for Aaron, since he's the one leading that.
Aaron has his hand raised. Aaron, you can come on screen if you'd like to share.
So we are working right now to finalize the language, and we fully expect to send it out before the beginning of the subcommittee, before we start on Monday.
So like 10 minutes before or like time before, just so that folks are clear.
We hope to send it out as soon as possible. And that's our intent, to send it out as soon as possible, but it will go out before Monday.
Okay, and the two other questions I have are probably best answered by Aaron. So I'll just keep you a little while longer, Aaron. So will the department have proper FMCS or department staffing for the next session of the Prison Education Subcommittee? Since that was kind of answered when we were talking about it earlier, when Stan, Professor Andres, and Dr. McTeer had presented earlier about the first session of the subcommittee. So just wondering.
I think Emil explained it a little bit last week, because the subcommittee, or yesterday, or maybe 2 days ago, because the subcommittee is organized differently than the main committee. You all have the right to the power to vote on the issues, and you all will be making the ultimate decision on what happens, whether you vote for consensus on the prison education language. We won't be having formal facilitation from FMCS for the 18th, 19th, and 20th. However, we do have, Dixie, did you get a chance to view some of the subcommittee? I'm just wondering.
Did not. I've talked to some of the subcommittee members. That's why I'm asking the question.
Okay, so we did
they've asked.
Oh, okay. Yeah, so we did have a member from the Department of Education, from my specific team, noting who was raising their hands, calling on individuals. And I did take on a little bit of the facilitation role in some of the temperature checks, but we do have a note taker. We have Vanessa Gomez, who projects the red lines. Our facilitator was Sophia McCardle from the Department of Education for the second 2 days, and Brian Schelling for the first day. So there are multiple. We had David Musser, who served as a technical advisor, providing FSA's, the Federal Office of Federal Student Aid operational perspective. We also had 3 lawyers. We had Soren Lagarde, Steve Finley, and Ronald Sands. So we did have a lot of collaboration and a lot of support from the department staff during the committee. I hope that answered your question.
Yeah, that's super helpful.
Let me just
and I have one more, Cynthia. I'm so sorry.
Dixie, let me just weigh in on that FMCS facilitation. According to your protocols that everyone accepted, it says that DOE would be the facilitator, and that is the past practice of these rulemakings with the DOE, that they have facilitated the subcommittees. Okay, thank you.
I've asked because subcommittee members have been a little bit confused about it. So yeah. And then my last question, I'm so sorry, Aaron. Since we voted earlier in this week to have a new negotiator to the full committee, is there going to be any actual proper onboarding for that person? And then also so that they can participate in the subcommittee next week?
We've reached out.
Right.
Sorry, I don't want to speak over you, Aaron, but FMCS has reached out to that individual on behalf of the committee, and I know that the department has reached out to that individual on behalf of the subcommittee. There has been no response to either one of our groups from that individual, Dixie. So yeah, the outreach was there to do the onboarding, but thus far we haven't heard back.
Alrighty, that's helpful. Thank you.
Thank you. Okay, David.
I wonder if in our outreach to that individual, if we offered them the option of just serving on the subcommittee. I've always felt all along that asking them to serve on the main committee was probably a shot too far, given the topics and the time commitment and the short-term notice, but maybe the subcommittee would be more attractive to them given their expertise and the much smaller time commitment.
Thank you, David. I'm going to let Kayla answer that because she did do the outreach to her.
Yeah, so this individual could in fact accept the role on the subcommittee and not the committee, or both, or the committee and not the subcommittee, since you all reach consensus on both. And that can be explained to her if and when we do connect. But agreed, David, she's got to be, accept and be available for those. I hope that answers your question, David.
Stan?
Hi, good morning, everyone. So just to weigh in on that, I've reached out to Director Ann Precythe's assistant and have a meeting with her today to talk and give a little bit more information. So I can hopefully provide some information to the committee later today on that. And I also communicated to Director Precythe via email, and will inform her assistant when I talk to her of the option of choosing one or the other, and kind of explaining what you've just said, David, and that where her expertise can best be suited. So I will look to update on that. Regarding the piece, I stayed after and just asked a quick question to the FMCS team a couple days ago about the facilitation in the subcommittee, and the response was exactly what was just mentioned. And as was also mentioned, our concern was that Aaron, although amazing, is kind of doing two roles in serving as also the expert, part of the expert team on the department and facilitating. Whereas here, the facilitators are, just facilitating and not having to also be an expert on the topic necessarily and provide their thoughts on the topic. So there's a little bit of a conflict there that, the facilitator is also one of the experts discussing the, in the discussion.
Thank you, Stan. An additional point on this is that these subcommittees are working groups. They don't have the option to vote or do anything or do consensus checks. They're working groups in the sense that the people that have been selected have the expertise and knowledge to try to come together to bring a recommendation to this full committee for for your voting abilities. This subcommittee is the only one that has that, or this committee is the only one that has that voting authority. So I don't know if that's helpful or not, but let's keep in mind they are a working group. Okay. So with that, I would like to move ahead and continue the discussion on income-driven repayment plans. Jennifer, you started to walk us through yesterday, sections A through D. I think we only got through A and B, but I don't know if your preference is to start fresh and go through those four subjects. We will be breaking this down into 5 different sections for the temperature check for ease of understanding.
Thank you, Cynthia. So again, if we could cue the income-driven repayment plan proposed text. You may recall we had, out of all the issues when we came to session 1, this was the most open-ended. We're coming back with proposed text, again, with a lot of questions for you all. So this, we are soliciting your feedback, your targeted feedback, your priorities in the context of Raj's presentations on IDR in terms of which levers to pull, in terms of income protection, and payments. So we have a lot of questions here. Just to reframe this discussion, There was a question about a mandatory tax. Again, we've taken this opportunity to revise everything in section 209, even the existing plans. Not so much substantive issues on the other current four plans, IDR plans. However, technical tweaks here and there, and we've flagged those issues for you. We stopped, I think, rather abruptly yesterday, and we're really getting into this discussion. Daniel had a question on, let's just axe everything and have one plan. And our substitute for that was to revise this to make it streamlined and less confusing. We can't get rid of the existing plans because borrowers are currently on them. So we need some governing regulations while borrowers and students are still on those repayment plans. So that's one I wanted to respond to Daniel. The second one, we were soliciting definitions. So we've gotten through, I touched upon how this is framed under other definitions. Under one, we've basically pulled the relevant definitions in the existing text and just kind of defined to which plan they're pertinent to. And we were soliciting, hey, we captured it all? Do we have all the definitions here? Jerry made a good point about defining consolidated loans. And I didn't get to loop back with her, but we have, as you can imagine, we do have that defined elsewhere, and that is at the beginning of 685.102 under definitions. That's the general direct loan program regulations. So we already have that elsewhere. So where we left off was at the bottom. I think we did get to D. I think we did get through this first part. There were a lot of questions that we didn't get through. And again, the flag at the bottom of page 2 under D, eligible loans. We want to solicit feedback on types of loans here, and considerations of how loan type eligibility interacts with cost and potentially other design parameters. And I do request that as as we touch upon these different levers and different priorities, if you could frame your suggestions in the context of those levers in terms of, again, what we're trying to get at here. We're trying to get at the affordability of these plans for lower income borrowers. Michaela had mentioned the 20 to 25 years. Again, we have the 10-year standard repayment. We realize that the 20 to 25 years may be too long for borrowers with lower loan amounts or who have lower incomes for longer periods of time. So just kind of keeping these in the back of your mind. If you could frame your suggestions in those contexts, we appreciate it. I see a lot of hands up, and I will.
Okay, thank you. Justin.
Okay, on the mute button. So there are a lot of other people on this committee that are much smarter on IDR than but I'm just trying to get some clarification on the department's intent with regard to the other plans. Certainly understand that there are people on these plans that will presumably may even want to continue on these plans when this new plan goes into effect. But I'm trying to better understand whether the department is seeing that as a permanent obstacle to consolidating and simplifying the options available, or whether there is still some consideration here to, potentially consolidate and make this easier for folks to understand. I understand the department wants to improve these as well, but I think there really is confusion out there, partly because of so many different plans. So again, there are many folks that are smarter, but if I could just get some clarification on the department's intended strategy around consolidation of plans, that would be helpful.
Jennifer, you're off mute.
I can just quickly say that nothing is reflected here. We're just adding the plan because we realize that at this point in time we haven't, not that we haven't explored that option, but certainly some of these plans could be sunsetted. But we right now we're trying to gauge what is needed, what is missing, so that we can reorganize this and streamline this with what we have currently. We certainly can't get rid of any plans right now in the regulations, but we are exploring how we can better organize these plans and see what's needed right now. And we're trying to address what is needed.
Thank you, Jennifer. Bethany.
So I actually have a follow-up on Justin's question, which is not why I raised my hands initially, but are there legislative solutions that would allow you to consolidate all of these plans and simplify the process for, is that what the department is effectively saying, that you guys need authorization from Congress to consolidate the plans?
I'm gonna let our general counsel respond to that.
Brian?
Yes, there are some statutory issues. For example, in IBR, there in the income-based repayment plan, Congress has established two separate plans depending upon where the borrowers are when they took out their loan. We can't abolish IBR. We can't stop new borrowers from signing up for IBR. That's statutory. In regard to ICR, those plans are created largely by regulation. However, for past borrowers, their promissory notes give them the option of signing up for pay, repay, and ICR. So that's a term of the contract right now. Whether those programs continue in their current form, I think that, as Jennifer said, that's something that, or continue to be available going forward, that's something that we're continuing to look at.
And so the goal with the new plan, sorry, I'm just trying to understand the big picture so we can move forward here, would be everybody starts using the new plan then, but the older plans are just left over for the people who currently exist in them?
I think the department is still looking at that, and whether there's other options. I think the department is still open to what the committee has to suggest or so.
I would just say that, I think what you're hearing from Justin and from other folks in the chat is just that people are very confused right now. Having 4 options or 5 options is just really messy. And so the more that y'all can simplify that, I think, just speaking on behalf of myself, that is something I would like to see in this. But my actual comment was related to B6, the definition of discretionary income, because I think we heard some comments yesterday during the comment period about childcare expenses, about other expenses that weren't taken into account when it comes to discretionary income. And I went back last night because I was curious, and I read subsection E and subsection L, which are referenced there. And certainly one way to get at this is the department to just increase the applicable poverty guideline percentage to 250 or 300. But I think another way to think about it, and I know that that's more complicated administratively, but the costs like childcare should not be counted towards discretionary income. That's not really discretionary. And so has the department thought about adding more specific costs that folks experience to that list, such as rent, such as things like that? I think that's one way to do it if you don't want to increase the applicable poverty percentage guideline.
All right. Not seeing a response for that right at this moment, Bethany, so they'll have to get back to you on that. Persis, you're up next.
Thank you. I want to both address the simplification and also move into discretionary income. I mean, I think part of the issue, regardless of whether you think you have the authority to, is what we need to do is we need to make this plan better than all the other plans. And I think that's why the plans are so confusing, is because one treats interest in one way, which is a little bit better than the other one, but the other one has a cap. And what you need to do is we need to make this plan so clearly better. You know, when we look at the FEL program, for example, we did not actually get rid of income sensitive repayment, but income based repayment is so clearly better that that basically very few people wind up in income sensitive repayment. And so I think we need to follow a similar approach looking at these new plans, is that we need to make the plans so clearly better that it is always going, the servicers are not going to be confused in walking through 12 pages of different income dream payment plans, that there's clearly one that is better for every single borrower. I think you could probably sunset all the other provisions if you also did that as well, to make it regulatorily easier. But I think in either event, so long as our focus is ensuring that we have a more generous repayment plan, then simplification just happens and we can let the other plans wither on the vine, so to speak. I think getting to the discretionary income definition is one of the most important ways of doing that, and that's why we proposed in the proposal that we sent you, we made the argument that you need to increase that to 400% of federal poverty. One of the biggest problems, as Bethany just mentioned, is that there are a lot of variations in the different ways that people have expenses. This is and not just expenses, but also what resources do they bring? And this is very true in particular for communities of color, that, you know, because of the racial wealth gap, borrowers of color have fewer resources. They have fewer resources to weather emergencies that come up, whether it's fixing your car or other type of expenses. But, you know, folks are supporting elderly parents. They're supporting community members. They are providing childcare, folks who have higher medical expenses. We just don't have a great way right now of capturing all of the different expenses that people have. I think 150% is probably not sufficient almost anywhere in the country. And I think if you look at the MIT living wage calculator, you can see that really in most places you have to get to at least 250 to 300% of federal poverty to really capture what's discretionary income. But then regardless, that's going to be your average, right? And we need to take care of the people with the extraordinary circumstances.
30 seconds.
And the way to get that is to have a very generous discretionary income threshold, unless you are willing to go through a more administratively burdensome process like Bethany suggested, where we are taking into consideration very individualized expenses. But I think we can either do the very complicated method of taking into consideration all these expenses, or we can have a very generous discretionary income threshold, and we suggest that we do the latter and that it be 400%. Thank you.
Thank you, Persis. Joe.
Hi. Thanks. So very quickly, agree with Persis on the need for this to be the best plan. And if we do that, then the concerns about there's a bunch of plans and we can't necessarily get rid of them, I think, are lessened. So 100% agree with that. One of the concerns for state AGs is the recertification process and people falling out of IDR through the recertification process. Was, encouraged to see some commentary about the Future Act implementation in the procedures section on page 6, and wanted to ask the department about in the procedures section, Romanet 2, not sure if I'm using Romanet properly there, but subsection 2, where the borrower has to consent to the disclosure of tax information in the master promissory note. Does the department know whether that consent would be ongoing for the, however long the program goes before forgiveness? We think that, we've seen servicers do a very bad job on outreach to consumers to let them know about research. We have that allegation in our NAMI complaints. And we think that, the less touches that are needed by the consumer or by the department or servicers have to reach out to them, the more successful people will be in staying in the programs. Secondarily, and a broader question is, for people who have signed a promissory note that doesn't have that provision in it, does the department have implementation concepts that would lessen recertification burden for existing borrowers, whether through the Future Act implementation or some other?
Thank you, Joe. Marjorie?
So I plus one everything that was said before me. I think these are really strong and concrete suggestions. I did want to go back to some of the points that Bethany had made in our first session about automation. And it seems for a lot of these issues, simplification would come through automation. So I want to encourage the department to think about things like Joe mentioned, recertification, how students get placed into plan. We've read both testimony and research that shows that these serve as unnecessary burdens to the borrowers. So in thinking about this process, I would encourage us to keep that at the forefront. In addition, when we're looking at this issue of discretionary income, again, agreeing with what Persis shared, and really thinking specifically about this idea of discretionary income and the differences in borrowers' needs, borrowers' expenses. So in support of 400, if that's the goal. And I think really the department needs to think about, so right now it just asks about, dependence and family size. We're still in a pandemic, and we know that things like childcare and housing are essential. Those are not, that's not my discretionary income. My kids have to be somewhere so I can work, besides in the back of my Zoom meetings, right? And so I really want to think about how we can create policies that maybe don't enumerate individual cases, but think more broadly about what we mean when we say discretionary income. And so that we're defining it beyond just this idea of what's the poverty line, because that line is very low and hasn't been changed in entirely too long. And so I don't think that's a good metric to even base this discussion on. If thinking about regional differences might be helpful to the department, I can go on several different websites and compare my cost of living. And so I don't know if using tax information in addition to where individuals might be filing their taxes from could be considered in this larger calculation. But I think that without making changes to that, really anything else we might suggest doesn't help to alleviate the burden, which is that these are either loan payments that borrowers can't make, or that they're so burdensome, they're detrimental to literally the quality of life and defeat the purpose of why most borrowers go get an education in the first place, right? It's social advancement, it's economic mobility. And
30
so
seconds.
We shouldn't be penalizing borrowers for doing what everyone tells them we should do. Thank you.
Thank you, Marjorie. Brian, I see you have your hand up.
Yes. Just a quick response to Joe's comments and Marjorie's initial comment. The department is also interested in reducing the burden on borrowers providing income information as much as possible. We hope to do that through implementation of the Future Act. We're continuing discussions with the IRS on what they'll accept as consent, because really it's up to them. They have to be comfortable. They're disclosing tax information, which they correctly like to limit, but we're working with them to satisfy their concerns as to where we get consent. Ideally, it would apply to both borrowers in the past whose promissory note and IDR form don't include the consent, as well as future borrowers, but it has to be something that satisfies their concerns about disclosing tax information and their need to ensure that borrowers have consented to it.
Thank you, Brian, for that. David, you're up next.
Seems like a lot of us spent have spent a lot of time thinking about the measure of income and discretionary income and the like, and how we might come up with a better measure. I'm happy, Brian, to hear that you all are looking at perhaps automating or drawing in at least better information, more information. You know, my thoughts between yesterday and today were really towards the research that overwhelmingly says that measures of wealth are far better than measures of income, which I think gets also at the idea of discretionary income versus income. And the challenge with measures of wealth is you have to draw from a lot of data sources to be able to come up with a valid measure. And I just don't know a way of creating an automated or simple way of doing that that doesn't end up putting on a lot of additional administrative burden on people that don't need or deserve that. And so I think I'm persuaded by Persis' argument that perhaps the most streamlined and efficient way of going about this would be to increase the percent of poverty. I'll be honest, I don't know what the right amount is. Maybe, I mean, perhaps 400% is the right level to give us what we need. I don't know if there is, and Persis, maybe you have this, any research or data that would kind of validate that 400%. I'm not saying it's not right. I'm happily go along with it, but it would be nice if we could provide some empirical justification for the threshold that would make some sense. You know, it's one of these challenging areas where better data, I think we could really nail it in, and something around wealth, discretionary income, excuse me, would be where I'd want to go. But I think in policy, sometimes precision ends up hurting the folks because of the burden placed on them to reach that precision. So anyways, thinking out loud, but I'll just end it there.
Thank you, David. Jerry?
Yeah, thanks. And every +1 to everything everybody's also said. And I just want to, for the record, just put in there whatever we do, which will be the best plan for everybody moving forward. I highly +1 that one, is to do things like eliminate the distinction between grad and undergrad. And also to put a cap that no matter what it is, you never pay more than the 10-year standard repayment plan. And that we allow as many people as humanly possible to switch to this better program that we'll create without penalty, so that they anywhere possible that they can do that.
Thank you, Jerry. Daniel?
Thanks. I have a lot to say, so I'll try to keep it within 3 minutes. So first of all, I support and respect and appreciate the comment about the Future Act. I will say, Brian, the timing is precipitous here. As we know, the 24-25 FAFSA is also going to have to rely on the Future Act as envisioned under the new FAFSA, and that's supposed to go live October 1/23. So this, anything we do here wouldn't be able to be implemented until July 1/23 anyway. So the timing would argue for, expansive thinking in terms of the ability to bring this to bear. In that, I would like to again reiterate what I suggested yesterday, that rather than create a new plan, that we change the default, we change the standard plan to an income-based plan, so that there is not a need for a student to choose. And that by certifying or by providing certification, their payment amount would be reduced. One of the notes that Raj made in the chat, and I appreciate this note, is a reference to the portfolio and a note of what percentages are under each. And doing some quick research, I did see that over half of the borrowers in the DL program are on the standard plan, either 10 years or less or slightly larger than 10 years. So, a concern I have is that students don't have to, or borrowers wouldn't have to make an active choice if this were the default. They would be protected without a need to go through delinquency, default, et cetera, if we could automate the linkage of the income information and by default or by nudge, just simply leave students in a plan that in that way could support them. They could always pay more. There's no limitation ever on paying more than your minimum due. They could always pay more. And I would want to see a cap at what the standard monthly plan amount would be to the 10-year repayment information. So, you know, if it comes through that an income-based borrower would owe more, to support Jerry's comment, it would be capped at the standard 10-year amount. That said, I also, and again, I'll appreciate if someone wants to check me on timing. The 400% to Persis, I support. I also would want to see some information about what is the right number empirically.
30 seconds.
Yeah, I knew I'd be running out of time. And what I want to make sure is that we also, in whatever plan we offer, deal with the balance growing problem, because I don't want students to be disincentivized by paying, you know, whatever they're paying and then seeing their balance grow over time. And finally, and I'll get back to this, Jennifer, I think all loans should be eligible. So to your point earlier about which loans are eligible, any DL loan should be eligible for this program.
Time's up.
Okay, thank you.
Hey, thank you. I just want to get in there. Thank you for touching on eligible loans. We're going to get to every issue, including recertification and the automation compelled by the Future Act. All these issues are important. I'm not trying to restrict how we talk about them, but just to kind of organize so we're clear on what we're left with when we leave. Right now, we're, if you guys could speak to what loans should be eligible and just to kind of help guide you with that. Currently, under the pay and repay programs, the eligible loans are direct loans other than Parent Plus and consolidation loans that repay Parent Plus. And then currently under ICR, eligible loans are all direct loan types except for Parent Plus and Direct Plus consolidation loans made before July 1st, 2006, except that direct consolidation loans made on or after July 1st, 2006 that repaid Parent Plus may be repaid under ICR. So that's kind of the scope that we're dealing with. What's available under ICR is more expansive than pay and repay currently. So, and again, we're limited on what, when we say all loans, FFEL loans would not be eligible under the current plan.
Thank you, Jennifer. Persis?
Thank you. So a couple quick things in terms of the support for the 400%. I did put that in the memo that was circulated. It's based upon both the MIT Living Wage Calculator and also borrowing from other federal statutes that have capped things at 400 is kind of like where I landed at that number. But that has been circulated. I know I haven't read everything thoroughly that's been circulated, but you can find it in there. I also do want to quickly support Jerry's point about the not making the distinction between grad and undergrad. There was a really excellent article in Market Watch by Jillian Berman earlier this week, which I'm putting in, which talks about the disparities on wages for Black women in particular, and found that Black women with graduate degrees make on average $7 less than white men with undergraduate degrees. So you can find that data, and I think that very much supports if we are using a racial justice lens to think about these proposals on making sure we don't have a distinction between grad and undergrad. But to Jennifer's question about eligible loans, which is actually what I raised my hand to talk about, I think it's very important that we make sure to be as inclusive of Parent Plus loans as we can possibly be. Parent Plus borrowers are left out in so many different ways. Again, there are large racial disparities on Parent Plus borrowers. Students of color rely on their parents disproportionately. Low-income students of color rely on their parents disproportionately to take on these loans. We've had a number of clients who make, make the minimum wage and wind up with $50,000, $100,000 in Parent Plus loans and have absolutely no way to pay them back. I realize that there's a statutory barrier to just allowing all Parent Plus borrowers to access the plans, that they have to jump through this hoop of consolidation, which I hope that Congress, and if there's a creative way administratively to do so, that we can eliminate that hoop. But I think we need to make these plans available to Parent Plus borrowers as much as humanly possible and be as expansive as possible, because especially low income parent borrowers of color are struggling right now to be able to afford those payments. So I will make that plug. The other piece that I think we heard a couple folks during the public comment talk about spousal consolidation loans.
30 seconds.
Thank you. And this is a very small population of folks. All of these loans were taken out before 2006. I did a FOIA for this data. There's fewer than, I think, 20,000 borrowers remaining in them. Arguably, we could just cancel all of these loans and be done with them. But if not, but short of that, we need to come up with some procedure to ensure that they are able to meaningfully access it, especially for co-borrowers who have divorced and no longer have access to their spouse's income. We need to come up with some procedure to get them affordable payments. Thank you.
Thank you, Persis. Appreciate it. Michaela.
I believe that the question that Ed is asking right now is specifically on loan types eligible, right? Just want to check because I got a lot of other things to say, but I'm trying to be mindful. So on that, to include all of the loans that we can include. So you're saying what I heard is we can't include parent, what? One of the parent ones, right? Sorry, I didn't quite write it down right, Jennifer. And we can't include FFEL.
Yeah, there are some restrictions that we can't include FFEL. We can include Parent Plus to the extent that they were paid off by direct consolidation loan. After the date.
So then, do any of us object to including all of those, except for the ones that we can't? Can we just say that and just decide? Is that what you're asking for right now? Cool. Well, then that.
Thank you.
Okay, thank you. Persis.
Thank you. And so the other piece that I wanted to talk about as we talk about eligible loans, and this may not actually be the place to talk about them, but since you raised fellow borrowers, I think it's at least worth putting in a flag here that while I understand that the ICR statute does not apply to fellow borrowers, what I do think can be captured is time that borrowers with FFEL loans that were then consolidated into the direct loan program, the time that they paid in income-based repayment while a FFEL loan, I believe is allowed to be captured as qualifying payments towards cancellation at the end. So even if we can't, extend this plan, although arguably if we're talking about the IBR statute, we could extend this to FFEL borrowers. But regardless, FFEL borrowers who then consolidated into the direct loan program should be able to count the time and the payments that they made towards cancellation under this plan that we create.
Thank you, Persis. Daniel?
Sorry, and again, maybe I need some orientation on this. Brian, can you point to the statute around exception of plus loan under IBR? Is there a particular carve out that is referenced?
It's in (20 U.S.C. 1087 D 1D, which says in describing repayment plans, an income contingent repayment plan, except that the plan described in the subparagraph shall not be available to the borrower of a federal direct plus loan made on behalf of a dependent student.
Okay, so there is a particular carve out, and where is the exception granted on consolidation? Again, is that particularly available through that same statute?
Because federal consolidation loans are not excluded from coverage, a borrower who consolidates a direct plus loan or a FFEL plus loan into a consolidation loan is eligible as owing a consolidation loan, not a plus loan. Interestingly, under IBR, Congress specifically precluded that option for IBR. They said, except that the IBR plan shall not be available to the borrower with a federal direct plus loan made on behalf of a dependent student or a federal direct consolidation loan if the proceeds of such loan were used to discharge the liability on such federal direct plus loan, or a FFEL plus loan. So they specifically precluded it in IBR because we had already allowed it in ICR.
So again, just to push a little bit, if we were to change the definition of a standard repayment plan under plus, would that get to this, or are we prohibited from that regulatorily to allow consideration of income in the definition of a standard repayment plan for plus borrowers? So I understand that there's been a definition congressionally of an IBR and an ICR. Is there a definition of a standard plan, or could we make the standard plan also something that considers income?
I would just like to, I mean, first I have to note that the standard plan has really, since the programs were established, been the 10-year plan. If you look at, so I'm not sure we can change the definition, but that's something that the department can consider and take back. Also, there is a provision in the ICR statute that says if a borrower of a loan made under this part does not select a plan, the secretary may provide the borrower with a repayment plan described in subparagraphs A, B, or C, or paragraph 1, which is the standard 10-year repayment plan, a graduated repayment plan, or an extended repayment plan. It does not include an income-driven repayment plan as one of the ones that we can choose on behalf of the borrower.
Thank you for that clarification. I appreciate it. So again, I would support with that Michaela's comment that any loan we can make eligible for this, we should. And we should be creative about trying to make other loans eligible if possible.
Thank you, Daniel, and thank you, Brian. Bethany?
So I want to go back to Percis's point and emphasize this because I think this is actually important, and I appreciate understanding if the department feels they're limited in any way in this space. But so if folks transition to a direct consolidation loan, their loans are then eligible for this. But the payments that they made previously could count. Is that something we can regulatorily change? Because it seems to me that that's where most people get hung up on this, is that their previous payments won't count if they consolidate. Can we change that? That was my understanding of Percis's proposal. I could be misunderstanding it, but like if we can do that, like that seems to me to solve most of the problems here.
Okay, thank you, Bethany. It appears as though that's something the department's going to have to get back to you on once they have some more information on it. Appreciate it. Jennifer, I'm going to ask you this. I don't see any more hands for discussion. I know we had said A through D, and you had walked through A and B. Do you want to continue on with C and D before the temperature check?
Oh, I think we hit D.
Oh, did we? Okay. All right. All right. So we've gone through all 4 of those subsections. So let's go ahead and do a temperature check on subsections A through D in the income-driven repayment plans document. So if I can see your thumbs. Okay, thank you. There are a number of thumbs down. I'm going to ask at this point if there is additional information that anyone who had a thumbs down that you either haven't shared or need to share, please raise your hand. Jerry?
Just the fact that this is more confusing to me than the way things are written now. I'm trying to figure out how to talk people through this. Yeah.
Okay, thank you. Anyone, David?
Yeah, I mean, I definitely think the 150% is just not backed by the data or research, and so we need to move higher. I reviewed the justification that the legal aid folks included in their memo. I find it persuasive, and so I'd love to get up to 400%. I also think there have been some other ideas that have been tossed around that I think have some potential. I'm not at this point able to accurately understand their feasibility, though, and the conversation has moved kind of quick on that. And so I think some additional exploration about the legal, our legal ability to make some of the innovations that would have been suggested needs to be investigated. But the 150% is just, I don't think that's justifiable, and I think it's doing harm. And so if we do nothing else, moving that up would be a major victory for students, and I can't support 150%.
Okay, thank you, David, for that. Jennifer, is there anything additional?
I see a lot of nodding, so I'm understanding that a lot of the thumbs down is pertinent to the 150% of the income, discretionary income. Also, to Jerry's point, and I understand the concern with regarding trying to organize and communicate the rules of these plans. This is our attempt at, if you look at the current regulations and do a side by side, I do feel like we've significantly kind of cleaned a lot of these issues up. By definition, you know, in terms of what we need to define, what we need to consider, I realize it is complicated, and we have to put that in words, and we have to put that in regulations. So this is our cut at it, I guess.
Thank you, Jennifer. Justin?
Yeah, and I just want to make sure, and one of the things, I agree with everything David just said, including the 150 piece, but I just want to make sure that it doesn't get lost in the shuffle, that I think there are a number of things the department needs to come back to us with in terms of clarification, you know, with regard to their authority to do some of the things that were asked. I don't have a full list of those. I know Bethany, I think, raised a point, you know, payment counting, and there were a number of other things I think the department needs. Well, I would certainly appreciate if the department would clarify they have the authority to accomplish, you know, in what we just discussed. So just want to make sure that didn't get lost in the very valid points about 150. Thanks.
Okay, thank you, Justin. So at this point, let's go ahead, Jennifer, and walk through the next breakdown, E and F.
Okay, make sure I'm seeing. Okay, moving on to E. E is the treatment of married borrowers with regard to income. So unless a married borrower certifies that the borrower is separated from the borrower's spouse or unable to reasonably access the spouse's income, a spouse's income is included in the calculation of the borrower's monthly payment amount for the tax share of the income the secretary uses to calculate the borrower's monthly payment under the following conditions. And we flagged B and C for negotiators in terms of whether the new proposed, I should say the proposed ICR plan, which we're calling EICR, again, we're open to recommendations on the name there, should go under B or C. And for B, the way we treat this for IBR and pay is if the borrower and spouse file a joint federal income tax return, and for repay, regardless of whether the borrower and spouse file a joint federal income tax return. And the question there is whether the proposed plan should go under B or C. F, setting payment amounts. I'll just keep going and then we can talk about all this. Just a quick note, again, this has to do with also streamlining the current plans. Just a flag that this section F on setting payment amounts would eliminate existing rules where we round payments that are $5 or less to 0 and those that are $5 to 10 to $10. So that's an improvement that we made in this section. Also, this would replace IDR payment application rules, which currently prioritizes fees and collection costs, which we don't charge to borrowers in IDR instead of interest. So those are improvements that we made in that section. Further down on page 4, at the top of page 4, again, okay. Setting payment amounts under 4, we have a note for the repay plan. Again, so today, if the borrower leaves a repay plan voluntarily or otherwise, if we try to get back into repay, we calculate what the borrower's payment would have been in repay for the time they weren't in repayment, and then adjust a new repay payment upwards, where we found the borrower got a lower payment by leaving repay. The total amount of the difference is amortized over the remainder of the repay forgiveness clock. So we've put forward some just payments are 10% of discretionary income divided by 12. Under 5, for the proposed EICR plan, payments are to blank percentage of discretionary income divided by 12. This is where we need some discussion here. So again, we're interested in alternate ways to address payments. For example, you know, should we consider a marginal approach in which amounts just over the $0 payment threshold have a lower payment rate? We're also open to suggestions on other ways to consider targeting, which could include concrete thresholds based on actual dollar earnings, not calculating it on a marginal basis, or any other ideas. And again, if you could frame your comments in terms of a sense of prioritization between lower payment rates, higher income exemptions, interest benefits, and forgiveness timelines. Furthermore, just feedback on whether this plan, the proposed plan, should be set as 1% for all borrowers, regardless of income, or again, whether we should take a marginal approach that could result in a lower percentage for the lower incomes. The latter approach would look like the below. So whatever percentage of the portion of discretionary income that are greater than 150% of the applicable federal poverty guideline and less than or equal to blank percent of the applicable federal poverty guidelines divided by 12, plus whatever percent of the portion of discretionary income that are greater than whatever percent of the applicable federal poverty guidelines divided by 12. We could probably really use Raj's assistance in kind of working some of this stuff out here on page 4. Let's see, why don't we, I see a lot of hands up. That's a lot to digest. So why don't we take a pause there and take questions.
Thank you, Jennifer. Bobby? And Aaron, could you stop sharing, please?
I think Daniel might have had his hand up before me. I don't know if he meant to get out of line or.
His hand is down, but.
Yeah, thanks, Bobby. I'll go back in line.
Okay, Jennifer alluded to this at the very end. There's a whole lot to digest. I'll probably have to come back around, but I wanted to comment on the marriage piece. Again, there's a disincentive to get married because of the consideration of the spousal income. I can almost guarantee you there are individuals out there that are not getting married because they consider if they're in one of these plans that their payment is going to double. And then for the rest of them, they're too much in love to even think about how getting married is going to affect their student loans. It's not like they got down on one knee and say, okay, oh, hold on, honey, before I propose, I got to check how this is going to affect my student loan payment. So I'd like for us to consider a way to kind of rectify that, and perhaps consideration in the EICR payment could do something like maybe we may want to consider a 5% and give those marriage folks a route to kind of address that. On another just kind of thought, and I'm not quite sure if this is allowable, but there is so much to digest in this particular section. I wonder if it may be incumbent upon this larger committee to create a subcommittee to review this in the time that we have between this session ending and the third session beginning. I just kind of wanted to put that out there as well. And then I'll go ahead and stop for now because there's a whole bunch of other things I need to digest. So thank you.
Thank you, Bobby. Persis?
Thank you. I also wanted to start with the married borrower piece, and I circulated yesterday a memo that a bunch of us had drafted back when we were negotiating the repayment plan, and this was initially considered to say that it is extremely important to have some avenue for married spouses to be able to separate their income. And currently under IBR, it is through, folks who file their taxes separately. I agree that like marital status does not make a ton of sense in this day and age about what someone's actual financial expenses are. Some people who are not married are cohabitating and share, household income, and some people who are married do not share their household income, and that's very real. And I think one of the particular things for the folks that I represent is that victims of domestic violence are particularly vulnerable and need to make sure that they have an avenue. Through the repay negotiations, we did create this check, this box that you can check, but the administration of this, for the requirement to have all spousal income has created a huge administrative burden for folks. For married borrowers who file separately in the other plans, they are now being required to provide their spouse's income, despite the fact that I think that there's probably no legal basis for requiring their spouse's income, and it is causing a lot of recertification headaches. And as we're thinking about implementing the Future Act, this is again going to cause nearly impossible to do. So I think we need to have some method of allowing spouses to separate their income. I think the tax code, the federal tax code, the Department of Education, the IRS would treat married borrowers differently doesn't make any sense to me. It has an avenue for folks to separate their income. There is a consequence to do that. There's a financial consequence. They lose access to credits. They lose access to other benefits. So maintaining that separation through that means, I think, makes the most sense. And I think it is the most protective for the folks who need to be able to separate their income from their spouses. And so I encourage folks to take a look at that memo. Some of the numbers are now out of date, but I think importantly, like it's very important to have that option available for spouses and to not create this weird wonky system that we created that's causing borrowers a lot of problems.
30 seconds.
Thank you, Persis. I just want to make note before the next speaker that John Whitelaw has come to the table in place of Bethany Lilly for individuals with disabilities or groups representing them. Marjorie, you are next.
Thank you, Cindy. So definitely +1 to Bobby and Persis. Thank you. And the other point, and maybe this is a question. So it's not clear to me why we would count spouses' income but not their student loan debt. And so we're basically double charging married couples because they're married. So that doesn't make any sense. So my proposal would be, if we're dealing with spouses who both have student loans, then any calculation should take into account both of their loans and not penalize them because of their income. And we do it in, so section 2B, that does happen in some cases. So the proposal that I have is that we simply, for all spousal borrowers, that we're considering the fact that they both might have student loans that they're paying off for the household.
Thank you, Margie. Carol. I should note that Carol is in for proprietary schools in place of Jessica.
Thank you. Coming back to both Persis and Marjorie's points with concern on counting spousal income, it isn't consistent amongst the different types of repayment options. And where I'm concerned is the communication to student borrowers when they are choosing different repayment plans, making sure that they understand the consequences of the different repayment plans and whether or not their spouse's income is taken into account before they choose those plans so that they can better understand the negative consequences if that's the case in that situation. And also concerns over requesting student feedback to dispute conflicting marital status based on tax filing status. It's not always reasonable for low-income borrowers to expect them to update that in a timely manner within a certain time frame, especially when their housing situation has changed or there may be extreme housing instability at that time, which wouldn't allow for them to address that discrepancy before they fall into extreme financial duress. And also the ability to contact students during that time frame tends to really be an issue for low-income borrowers. So I would ask that that be considered when taking into consideration including spousal income.
Thank you, Carol. Jennifer, I see you're off mute.
Yeah, just real quickly to Marjorie's question. You know, under 2A, to the extent that the spouse's income is included, so is a loan debt, to answer your question. Mm-hmm. And what I'm hearing, and please correct me if I'm wrong, is the general discussion is leaning toward B in terms of filing a joint spousal return for the inclusion of the proposed plan. But let me know if I'm not here.
Okay, thank you, Jennifer. Persis?
Thank you. I'd like to also now talk about the setting the payment amount section as well. And so I appreciate the various different options. I think, from our sense, the biggest priority for the legal aid community is protecting the largest portion of income. I think that has the biggest impact for the lowest income borrowers. And so however we can do that, I think would be important. And I would definitely look to Raj's modeling to see how we can do that. And if we can look to see more really about real world data and what borrowers' real financial circumstances are, I think that would help inform this conversation. The other piece I want to say is I think that this is also an opportunity for us to be a little bit more creative on how we define what the payment amount is. And I think back to our conversation about interest capitalization and how deferments, for example, are statutorily required to capitalize interest, but income contingent repayment is not statutorily required to capitalize interest. And so one of the things that I would like to propose is that we actually create new different ways of determining payments so that if anyone qualifies, for example, for one of the deferments, we actually just presume that they have an income contingent or EICR or whatever we're calling this payment plan, payment amount of 0. And I think we could do that for more than just the existing deferments. I think we could create new deferments. For example, we have the cancer deferment, which I think is very important, but why not other medical categories as well? So I think that this is a way that we could be more creative in determining the repayment amount. And I actually do have some proposed regulatory text that I can drop in the chat on a really simple way to at least capture the existing deferment plans and giving them an automatic $0 payment amount, which has the benefit that then they count towards cancellation. They don't have to have their interest capitalized. So that is my proposal for your consideration.
Thank you, Persis. You read my mind. I was going to ask you if you were going to put forth some reg text, so I appreciate that. John?
For just a couple of brief points. And I think for most of the people on today, this they will understand this, but I do think it's important to note that the so-called poverty guidelines have got actually very little to do with real poverty. And so, because I think there's a perception amongst certain populations, perhaps outside this call, that if you're above the poverty line, you're not poor. And I think it's important to understand that just because you are, and I know most people on this call understand this, but I do think it's worth mentioning all the time. And I think continued use of the word poverty guidelines does imply that if you're at 200% or 300%, oh my, you can't be poor because you're at 3 times the poverty level. And I just think it's always important for us to remember that that is absolutely false, and that the poverty level is destitution for any family size. And I think just because you're above it, we should understand that that is not a real world number. The poverty guideline is not about poverty. It's a number that is set in an arcane way that does not reflect actual poverty. So I think that's just an important consideration for us to keep in mind as we work through this. And then just one other quick point. Persis noted that marriage is a very poor proxy for household in terms of what's going on. But I think to mirror that with something that Jennifer has said on numerous times, I don't think there's any interest in actually delving into the household to look beyond that. So it seems to me the better rule is to, where possible, disregard marriage, as opposed, because it's such a poor proxy, as opposed to because of the consequences of it, as opposed to trying to dig into the actual household components, because that would just be way too burdensome and intrusive. So having said those things, I will now be done.
Thank you, John. Daniel, your hand is up.
Yeah, thank you. I've raised and lowered it like 5 times already. But the issue that I just wanted to center in regard to what John said, and specifically around the marriage issue, is what always struck me as unusual in this regard is that if and when a student passes away, which hopefully, or borrower passes away, which hopefully does not happen during their loan repayment, but as we're extending repayment periods, it's possible, the debt is not an obligation of the spouse. So the debt is canceled as a result of the student passing away or the borrower passing away. So it doesn't make sense to me as why then we would base the repayment amount on the spouse's income, where the obligation is not jointly taken on. There is no liability for the estate or, as I understand it, for the surviving spouse. The fact that we would then assume that the spouse would have liability from an income basis doesn't really make sense to me. So in as much as that's helpful, I'll add that. I did put that in the chat as well.
Thank you for that, Daniel. Michaela?
Yeah, so for these sections, we're talking about one, the payment, but also one of the questions that was posed by the Department of Education was a sense of prioritization. And so I have kind of 2 questions on those kind of lines. One, I am very, very seriously proposing 10 years to forgiveness on this plan. Like that's not like just, and I don't think that that's totally absurd, right? You mentioned, like it was mentioned about the 10-year standard plan, right? But that 10 years to debt relief for pursuing an education shouldn't be just limited to wealthy people, right? Like we're literally conditioned as children to believe that if you don't go to college, then you can't do anything. Like I dropped out of high school and I worked really, really hard to get to where I am now in law school. And sometimes I wonder if I was just sold, more than $100,000 worth of debt for what? So that I can be paying it back for the next 25 years. So I can be paying it for the rest of my life when my son goes to college and I take out more debt. I think that it's really, really important to lower these forgiveness standards. I also think that 10 years is reasonable. I know that PSLF is also 10 years. I was actually listening last night for hours to the floor hearings from 2007 when they passed this bill. I needed to know. What they were talking about was that the PSLF, I know that's not what we're talking about right now, but I think it's important to mention since I am very seriously proposing 10 years. The PSLF was supposed to be, a Republican senator from Wisconsin said, a thank you from a grateful nation for your service, right? It wasn't supposed to be about bailing people out of unreasonable student debt. It was about helping folks, especially, middle class folks, be able to go into public service when they could go to the private sector, right? It was about acknowledging that they could make more money elsewhere and that this is, within kind of that middle class that might not otherwise qualify for other relief. So my overall question is, what is the intention with this plan? Are we trying to help the lowest of income folks, or are we trying to look at something that can create broad relief? And I think that's important when we're talking about what the payment is.
30 seconds.
The pressure points, so that we can actually find out what is reasonable and possible under this plan, or if we should target this as low income folks, and then maybe also look at the timelines on the other plans and lessen those.
Thank you, Michaela. Okay, I don't see any additional hands. So Jennifer, if you have what you need, you can go ahead and take the temperature check on the sections E and F only.
Sure, and well, I see Persis. Yep. I was going to frame this a little bit better, but go ahead, Persis.
Yeah, maybe you're about to get to this. I'm just confused since it seems like most of the things in this section are TK, how we can do a temperature check on it.
Just about to get to that. So, so a lot said here on this section on income, spousal income, and setting payment amounts. What I'm hearing about the spousal income, short of not considering it at all, given what is written here, I'm understanding the preference to be less restrictive, and B is a less restrictive option under income, if I'm hearing that correctly. Also, for setting payment amounts, what I'm hearing is more of a marginal approach versus a concrete threshold, and protecting the largest amount of income for borrowers generally. So, but yes, most of the stuff here is TK, but if I'm correct, if we could take a temperature check at least on the leaning towards, in the options that are provided, the leaning towards B rather than C for income, for spousal income. And then we still have a TK on 5 for the EICR plan. So let's just, if I'm, just please correct me if I'm wrong in terms of what I'm hearing, in terms of more of a marginal approach rather than a concrete threshold, or maybe I'm over stating that right now. And then we can take, if that is the case, then we could take a temperature on just those general concepts. Also, to Michaela's point, yeah, I mean, I think the idea here is, we are trying to get to those lower income, lower balance borrowers that seem to end up in default and delinquency despite the existence of these plans. So I'll stop there, and I see your hand up.
Yeah, I want to also just touch on default, not in the problem solving way that Persis is, but just, we want to address how folks are ending up in default. And I think really a broader issue is that we lack market participation. You have like a couple generations of folks now that don't see this debt as ever going away. And so there's no reason to continue either to like make sure that you're recertifying every year, because either way, it's just going to get garnished or taken. Like, we currently have a student loan debt crisis. Like, it's bad enough that we have like comedies on late night shows, right? Like, it's literally a joke, like how bad this is. And so I think that we have to look at how we're structuring a system and not tweaking a program, right? And I think that the only way to do that is to acknowledge what we're targeting with this program and how we can make the other programs work better.
Thank you, Michaela. Persis, did Jennifer's explanation of what the temperature check be help you?
Yes, that was helpful. Thank you.
Okay. So with that, let's go ahead and take that temperature check as Jennifer had outlined it. Can we see your thumbs? Okay, thank you. I see a couple of thumbs down. Is there anything that you need to share with the department as to why your thumb was down and what ideas you have that haven't already been shared to make a difference for you? Anybody?
Cindy, I just had a question. It's a question that popped into my head. I'm sorry. I can wait.
Oh, okay. All right, Jennifer, you good on this one?
I think so. I have trouble seeing. I saw Marjorie's thumb down. Is there anything that we can?
I didn't have anything new to add beyond what was already discussed and shared.
Okay. All right. Dixie, we're about to move into the next sections of G through J. Did you want to speak before that, or?
Yeah, it just mainly a question for Jennifer and the department. How do you define low income? Because on the first session, I talked about including a regional acknowledgement that 30,000 in one area is not the same as 30,000 in another, right? So to be poor in Orange County is very different than in another area of the country. And so the department has failed to just even acknowledge that, in the sense of in the text, even from the first session. And I think I made a point then, and a lot of other negotiators did too. And so I'm still confused as to what the department defines as low income. Because if we use a federal, the federal poverty guidelines, right, that threshold, right, that was protected and stuff like that, if we use that definition, like John just said, you are still poor. You are still poor, no matter, right, you are still incredibly poor, but also there needs to be at least acknowledgement, but also an understanding of the way folks live across the nation. And so the department, I need the department to answer that, because I've been trying to, and I've been thinking about it for a while, in this entire conversation, trying to think about how the department defines it. And so it would be incredibly helpful to define that, because for me, I am poor. I am very low income. And I know other folks with the same household income as me and would definitely not be considered poor in other areas, right? And so there needs to be acknowledgement of that, and also we have to then be okay, so if we define this as low income or as poor, etc., then how are we accurately just accurately providing relief for these folks, for folks who are poor, for folks who are low income. So if the department can answer that, or if there's a working definition that the department has, please drop it in the chat.
Thank you, Dixie. I think this is why this is so challenging. We are relying on poverty guidelines, and we have proposed 150%. I understand from the income protection. I understand from the discussion that there's an interest in seeing that number increased. We're also open to how much of the share of the income, percentage of the income we should, borrowers should pay on this plan. So those are all open questions, but your point is absolutely, I think, getting to the crux of this matter. We're really interested in those borrowers that are losing out, that are falling into delinquency, and trying to find a way to capture them in these plans and prevent that from happening. I don't know if that answers your question, but
it does. I think it gives me
relying on existing poverty guidelines.
No, yeah, it really doesn't answer my question, but the 150% covered in the federal poverty lines, as I think we've made very clear, doesn't even cover childcare, doesn't even cover rent, right? And especially in like cities like, or in areas like Orange County, Los Angeles, San Francisco, the Bay Area, New York City, right? DC, the DMV, that's not covering rent, that's not covering childcare, that's not covering transportation, that's not covering so many other things, and also the added costs that the pandemic has brought on to people, right? And so what your answer just, I think, disappointed me more, mainly because I don't think that the department has been able to, in the 3 weeks before, or in the 3 weeks in between the first session and the second session, I don't think thought about it. So yeah, it's disappointing, but so I'm out here supporting Percis's point, 400% should be protected, because the 150 wouldn't even cover the child care costs for the average parent. So yeah.
Thank you, Dixie. John, and then we're going to move on.
Just want to pose a question to Jennifer. She has said we use the poverty rates, but is that required? I know in lots of other areas the government doesn't necessarily use national rates. But I think what Dixie is saying is, look, different parts of the country, urban, rural, poverty, what puts you at risk changes depending on what part of the country and what shelter costs might be. Does it have to be a national standard? And I realize, and I'm just thinking this out loud, I haven't thought through the entirety of this. But there's lots of data about regional living expenses. There's lots of data about poverty. What's a living income depending on where you live. And the federal government does, in fact, use, for example, just on per diem rates that they reimburse their own employees when they travel, is not a national standard. It's based upon where you travel to. So I'm curious, and I realize it would not necessarily be the simplest way to deal with it. But it seems to me if there are two choices, right, I would suggest is you either pick a rate that's high enough to cover the cost of the person in the highest, and I'm going to use Dixie for this just because where Dixie lives, in which case that's fine, and then everybody else is going to be covered. Or you've got to figure out a way that, because if you pick a number that's too low, there's going to be a bunch of folks who live in high cost areas who are going to essentially not be protected. So I just wanted to raise that as a sort of in response to what Dixie said and in response to your answer to Dixie. So that being done, I'm done. Thank you.
Thank you, John. Okay, Bobby?
Just really quickly, I kind of want to mesh what John just mentioned, and maybe we can try and keep it as simple as possible. And also what Persis brought up earlier. And so in the question I have for Jennifer is, on this EICR plan, can we just completely knock it out of the park in terms of benefiting the borrower? You know, in terms of the threshold or percent of discretionary income, and as well as the percentage of, that was proposed earlier by Persis. Can we just have one knockout plan that may be extended, if it needs to be out over 10 years, but also it provides an avenue for those people that need to be in PSLF, right? So they can kind of go in that way and they'll have their loans forgiven in 10 years. So I just kind of wanted to bring that up, and maybe that's the way that we kind of address all of this, is by having one knock it out of the park plan.
Thank you, Bobby.
Can we knock it out of the park as well?
Thank you.
I'll second that goal, Bobby. I think as we get into these discussions, it's complicated, but we're having the conversation, and about these very complex issues concerning repayment, what borrowers need, what the pain points are, and so yeah, I mean, we're behind you in concept and trying to get there.
So in session 3, we are just going to be completely knocked out by this EICR plan, is what you're saying, right? Where none of us will have a comment, which like, this is the one right here. This is the one. All right.
That's what I'm hoping.
Okay. With that, Jennifer, are you ready to walk through G through J before we break for lunch?
Yes. So I guess, a big piece of this before we move on under G is this, how we're thinking about payments and setting payment amounts. So, we talked about this kind of marginal approach. So I think that's a huge point that we need to think about more. So if you could just keep chewing on that piece. And we are currently doing the same. There isn't G, H, I, and J is basically, again, just streamlining those sections. There is a note under I about changing repayment plans. They've simplified this section. Again, and I think to Jerry's point, it may have been useful to kind of hold up the current regulations. You guys can hold those up just to see. You could do a comparison right away. This is far shorter, and I didn't, in the temperature check, I didn't go back and flag those areas that we've improved upon in terms of the existing plans and the technical language associated with those plans. So this is another piece right here. And that's, eliminating the complexity around IBR today related to leaving IBR for standard and then only being able to leave for another plan if you make the payment or a reduced payment forbearance of $5 and paying that amount. So that section I simplifies that piece. The interest cap, again, is, incorporates the proposed interest cap, eliminating interest cap where we can for those that are non-statutory events. So it's incorporated there. So there isn't a whole lot there, but if you could look at the language, and we could take after people have comments and questions. I see Persis' hands up on that issue. So I'll go on mute.
Hey, Persis.
Thank you. So I very much appreciate
comments and questions. I see Persis' hands up on that issue. So I'll go on mute.
All right. Weird audio issues here. But so I very much appreciate both the elimination of interest capitalization, as I've said many times before. I also appreciate the intent of providing an interest subsidy for borrowers where the payment is scheduled to be zero. I think we can go further than that, and any time that there is unpaid interest can be subsidized, right? So I mean, I think absolutely $0 for the client that I represent, almost all of whom have $0 payments. The interest growth is just a big barrier, and they see their balances grow and they kind of wonder what they're doing here. But it's still true for folks who have, smaller, $10, $15 payments where they're not touching principal at all. They still have this interest growth. So I think a better approach would be to say that we need to subsidize any unpaid interest, right? So if we have borrowers who do have incomes that are high enough that their payments are covering the entire interest amount and touching principal, then we, we should, can continue to charge those borrowers interest. But for the lowest income borrowers, I think that this would be it would eliminate the cliff of this. You have no interest, but like the $10 payment you do, right? Just any unpaid interest should be subsidized, in my opinion. I also think, just for the purposes of creating the plan to beat all plans, you need to carry over the 3-year interest subsidy, just for the purposes so that we can phase out the other plans. As I understand the idea of making them more generous, I'm not necessarily philosophically tied to that, but I think it's important as we are approaching simplification. But yes, I'm happy to also draft some language of what it would look like to subsidize any unpaid interest, if that's of interest to.
Okay, thank you, Persis. Joe.
Yeah, I would just second what Persis said about carrying over at a minimum, carrying over the 3-year subsidy. And, maybe I'm missing something basic here, but is there a reason that it has to be capped at 3 years? Can we do more?
Okay, it looks like they'll, if you want to put that question in the chat, Joe, they'll get back to you. Thank you. Michaela.
I just want to echo what Joe is asking for the percentage, and point out that this is another time where we don't have an understanding of what our cost benefit analysis is on all of these choices. And so it makes it very difficult to allow us to have informed conversation about where we're willing and what we're prioritizing, because we're just throwing out mystery suggestions.
Okay. Seeing no further hands, Jennifer, are you good on this for right now? And we'll pick it up after lunch.
Yeah, we could do that.
Okay. My understanding that Josh is substituting in for Persis and wants to make a comment.
Yeah, thank you. I didn't want to eat up into the substantive for this, just as how important the IDR conversation is, but I did want to flag that I share the concern that David raised the other day, that we are really limited on time, not only for the remainder of the conversations that we need to have today, including on fall certification, which is really a critical issue for our client base, but the more general concern that there are a lot of open questions that it just feels really cramped to try and get answered and resolve everything with only one additional session left. So I understand Ed's position that it doesn't want to add or cannot add additional session days. But I also, from the protocols, understand that any negotiator can call for a caucus at any time, that the protocols don't limit the caucuses occurring within the session time, that the negotiator can set who is to join the caucus, and that the negotiator can set the agenda for the caucus. And so I just wanted to flag my intent now so that people can look at their calendars to call for a caucus to occur after the public comment session ends today, at some point between today and session 3, to include the Ed negotiator and any other negotiators who would like to join, to both discuss any issue where we aren't, that we don't resolve today that's on the agenda for today, and to circle back to some of the issues where I think a lot of us feel like more discussion is needed.
Okay, thank you, Josh. David?
I support that completely. I would say if people if it's too much of a struggle to work our calendars to add days between 2 and 3, I would also support adding days after 3 in a official negotiation table capacity rather than a caucus. Either is good with me. I don't know that that we discussed adding. I had proposed adding days. I don't think Ed responded to adding days. I think they responded to my other proposal of adding hours. But either way, I support either the caucus proposal by Josh between 2 and 3, or adding days after 3 and officially extending our negotiations.
All right, thank you. Jennifer, I see you're off mute.
Real quickly, so we wouldn't be able to extend officially. That would seriously jeopardize our ability to publish anything timely. Remember, we have a pending table and negotiations starting in the new year. But to the extent allowable under the protocols, they would be amenable to Josh's suggestion on caucusing.
Thank you, Jennifer. With that, we are at your lunchtime hour. So we will see everyone back here at 1 o'clock Eastern time and pick back up on the income-driven repayment plan. Have a great lunch.